filed a motion for Judge Aileen Cannon to reconsider an order that Smith says would identify more than 24 witnesses, exposing them to threats. But after reading that motion, Judge Cannon ordered Jack Smith to hand over that evidence to Trump's lawyers by today. Msnbc legal analyst Mary McCord is with us. She is the former principal deputy assistant attorney general for the National Security Division and co-host of one of my favorite podcasts, Prosecuting Donald Trump.
Mary, welcome to the table. So there's a lot of drama going on with Judge Cannon, and I've always thought this was sort of a live wire with her, and she's kind of proving herself to be that. Walk us through what's going on between her and Jack Smith right now, which, you know, seemingly to be fairly important.
Yes. So this all started when Mr. Trump's team filed a motion to compel discovery, a very broad motion saying we need all kinds of material from all agencies all over the entire government. And they attached to that a number of documents that would reveal these names of government witnesses, sensitive ongoing investigations. They filed that redacted and under seal for the time temporarily. The Jack Smith came in with his response, filing his attachments also under seal and saying that it would reveal, you know, put people in danger if their names were revealed, potential government witnesses, their statements that they've made, ongoing investigations. Judge Cannon then ruled earlier this week, sorry, no, you have not shown a compelling government interest in keeping that information redacted, that is narrowly tailored, and you're going to have to turn it over. What Jack Smith did last night is he came in and said, moved for reconsideration, saying, Judge Cannon, you made a mistake of law because you applied a standard of a compelling government need to a discovery motion. That doesn't apply here. Good faith basis to withhold sensitive information, including information that could put witnesses at risk, that is what is the standard. 11th Circuit has held that. Other courts have held that. So thing one, you made a clear error. Thing two, it would be a manifest injustice if this information were to be made public because it could put witnesses' safety at risk and compromise ongoing investigations.
We have a full screen of that of the 24-page filing in federal court in Florida about that wrong standard. And I mean, this comes, Mary, after a Texas woman was arrested already for death threats against Judge Cannon. And so, I mean, we already know about witness intimidation and the kinds of things other witnesses and even jurors in other cases have experienced when it comes to Donald Trump and his cases. How do you think this is going to shake out? Are we going to end up going back to the appeals court in the 11th Circuit? Are they going to swat her down again?
So I actually suspect, you know, she then immediately put her ruling on hold and told Mr. Trump's team they've got, I think it's till February 23rd, and forgive me if I got that wrong, to actually file a response. I do think that once she reads, you know, the law that Jack Smith has pointed out to her.
A judge reading the law. That's an interesting idea.
And reads his much more concrete. What he did also is come in with a lot more detail about details about what is at risk here, and points out the point you just made, Simone, that, you know, it's not like this would be unprecedented. We don't have to wait. And actually, what's interesting, he quotes at length from the D.C. Circuit's opinion in the gag order case, where the D.C. Circuit says we don't have to wait until someone gets physically threatened or attacked violently to take action. And where there's a record of people who are witnesses or otherwise involved with the Trump cases of receiving threats, FBI's been attacked, judges have received death threats. We don't have to wait for that to happen. We can take action. So Jack Smith cites that. He also has filed a separate under seal and ex parte pleading about a witness, a potential government witness whose threats against that person have been so bad there's an ongoing criminal investigation. Says this has got to remain under seal. So I think she will change her mind. If not, I do expect that he will take this up to the 11th Circuit on a petition for a writ of mandamus.
I mean, there is a subtext to Simone's question, which is, what is happening with Cannon? Do you think it is bias or do you think it's incompetence?
I think there's a little bit of both. I think there is some incompetence here. I mean, she applied the wrong legal standard, and it's not difficult to discern what the right legal standard is. But clearly she has revealed, since the very beginning of this case, a bias. And I don't know whether she thinks she wants to just make sure she is putting the government to its burden and not showing any favoritism for the government.
But she feels like she's showing a lot of favoritism towards Donald Trump.
Well, and to that point, to the 11th Circuit, they've already smacked her down once. And twice, exactly. I was about to say, correct myself. It was twice. I think a third smackdown would be the final straw for her in this case. You have a lot of folks out there looking at her in the legal community. I mean, it's not, you know, just us sitting outside, but in the legal community feeling there's something not right about how she's approaching this. How do you think this plays out with the 11th Circuit if it comes up that way, where they're like, you know, Jack Smith is like, Your Honor, we're seeking her removal from the bench in this case. What's the precedent for something like that? How does that play out as well?
So, and I don't know that Jack Smith will do that. I do think that if she does not reconsider, he's likely to take that up because witnesses' lives are at risk, and he's kind of got to try to take it higher. I don't know that at this point, even though I know this would be a third time, that he would ask for her recusal because the standard is really, really hard to meet. And I think there are enough things that she has done in the record that we can look at and think that they were unreasonable and think they show bias to Trump, but that she would have an argument. And she would have an attorney, you know, to argue on her side of this, that she would have an argument that, you know, she's just managing her cases and in the way she sees fit, and she hasn't done anything to show such a bias that she has to be removed. And I think it would be a heavy lift for her removal.
It is something to watch. That was the latest news. I think some other big news that happened this week was